Tony DeWitt here, Missouri appellate attorney, retired. None of what follows is legal advice. I'm here to do some video for you today to talk about an interesting subject on the law, and here it is. Thankfully, the prosecution in the young Dolph case brought in a female prosecutor to do the first part of the closing argument in that case. And she actually had an up-tempo voice, and she did very well in terms of keeping her energy up in doing the presentation for the jury, going through the law and the facts and laying out the case. Now, the only problem that I have, frankly, with the closing argument of the state is that it is effectively death by PowerPoint. There are a lot of people who will go to great lengths to do a PowerPoint slide or a series of PowerPoint slides, and then they will read the slides to the jury. And of course, the jury can already read the slides. PowerPoint is most effective when it's used the same way a note card can be used, or to illustrate some piece of evidence or some photograph or even some video that you want to play. But using it as your verbatim transcription of your argument, I think, tends to be off-putting to people, and it allows their minds to wander because they read the slide and then they think about something else. They feel the slide change, they look up, they read the slide, and they go on to something else. And as a result of that, it's not as effective for all of the people on a jury the way it would be if you were adding something to it or just using it to develop your themes. That's a minor point, but I think it's important when you're doing a closing argument that you captivate the people on the jury. You bring them into your sphere and talk to them like you would a group of friends. And I think she did a pretty fair job of doing that. I think she was certainly a lot more persuasive and a lot more eloquent than the prosecutor who did the opening statement. One of our commenters here said that he couldn't follow the opening statement because it just put him to sleep. And I kind of had the same reaction to that. But let's listen to a little bit of the death by PowerPoint part of this, and you see what you think.
So the defendant, Justin Johnson, is charged with 3 counts. Conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. So I know that you've already gone through a little bit of this law during voir dire, and especially through the jury instructions. But a brief overview of conspiracy to commit first-degree murder is that 1, this defendant entered into an agreement with 1 or more people to commit first-degree murder. 2, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, each party acted for the purpose of promoting or facilitating the first-degree murder. And 4, 1 or more of the parties committed an overt act to help the crime happen.
So in this first minute or so, she read from the slides. And again, I think that's off-putting. But as she went on, she started to expand and use the PowerPoint much more appropriately. Let's listen.
So what did we hear this week? This week we heard testimony from co-defendant Cornelius Smith. He testified for us, and he told us that he met Justin Johnson through Hernandez Golan, and that he knew Justin was a rapper, and he was also known by the name of Straight Drop. So Smith had known the defendant for a couple of months, and they hung out a couple of times before the murder. He was able to identify defendant in open court, and during his testimony, Smith told us that on November 17th, 2021, he and the defendant knew that Big Jook had a $100,000 hit on Dolph's head. Cornelius said that he and Justin agreed to kill Dolph together, and both of them receiving $40,000 apiece. Not only did he tell us that, he told us that this plan had been in process for weeks, and that Justin knew about it. And there were conversations previously or prior to this murder, and Justin Johnson was an active participant in those agreements. So there we have it, a conspiracy to commit first-degree murder. An agreement was made, Each of the parties had the intent to commit the first-degree murder. Each person acted for the purposes of promoting and facilitating. And, ladies and gentlemen, the overt act is the killing.
So, like I said, I think she's doing a pretty fair job of getting her licks in on this and letting the jury know what it is that the state believes caused this young man's passing. They relied on a lot of different evidence, and of course their theme was it's not 1981 anymore. And I'm not sure that that is necessarily effective. It may be if the jurors are young. If the jurors are all below the age of 40, maybe it is somewhat effective. But for people like me who were born in 1955 and who have been around for a while, we still remember 1981. It wasn't that bad, to be honest. So when you say it isn't 1981 anymore, I think it would have been a much more effective opening or even closing gambit to say, we're not going to talk about 1981. We're going to talk about 2024 and all of the technology that helped us put this case together. Now, I've always had a problem with the sort of the cell phone mumbo jumbo that they use to track cells and bounce it off towers and that kind of thing. Just because I think it's a huge intrusion into our personal privacy. And you know that if they can do that for a murder suspect, they can do it for any of us. And like I said, that seems a little big brotherish to me. But again, I tend to be a freedom absolutist as well as a First Amendment absolutist. So what can I say? But Luke Evans is going to get up next, and he is going to give his closing argument. And I think that this closing argument will resonate with the jury maybe a little bit more. As I'm putting this together, the jury has just come back and they have announced a verdict in favor of the state in this case. So I'm still going to put a little bit of this closing argument on, but obviously it didn't carry the day, even though I thought it was an excellent closing argument in this case. So let's watch a little bit right now.
So watch those videos. Watch them closely. They want to talk about those videos, and I'm encouraging you to study them. Give them a close look. The state doesn't want to acknowledge what I told you in opening, and that is similar. It doesn't mean the same. Plenty of people have gray sweatpants, black shoes with white soles, black hoodies. And as we learned through the proof, in Memphis especially, and elsewhere, Bass Pro has. You can look at it, if we had a window, you could look at it and you could see the Bass Pro, which is the pyramid here. You also heard testimony about it being a fad at that point in time. Famous rappers wearing it. Other famous artists. I think I mentioned Gwen Stefani wearing Bass Pro. One rapper has a signature Bass Pro hat. You heard from one of the detectives that they even interviewed someone who gave them a potential suspect that wasn't Mr. Johnson and said that person always wore a Bass Pro hat. You have to consider that. And then you have Sergeant Dabney, who, for the first time, and I think he acknowledged this, sitting on the stand, says, I think those underwear are the same. They're both blue. You look at the underwear from Tulane Apartments, you look back at the Makita video, those are the same underwear. Look at it. Look at the steel shots. And for yourself, determine, can you tell if those are the same?
Well, at the end of the day, poor Mr. Johnson is going to go to the big house, I think. And the problem for him is that although he had a lot of evidence on his side that helped establish some reasonable doubt, he didn't have enough of it to convince the jury that it wasn't him. And of course, it didn't help that his co-conspirator, Cornelius Smith, ratted him out. And Cornelius Smith is probably going to have a really difficult time in prison. And this gentleman is probably not going to have nearly as hard a time because, he made them prove their case. And he also has a chance to get out on appeal if, when Luke Evans appeals this case, as I assume that he will, he can show that there simply wasn't enough evidence to support a conviction, or that evidence was admitted that perhaps shouldn't have been admitted and should have been kept out. And who knows? It's hard to know what kind of motions and other things were filed behind the scenes that all of the public and most of us don't know about, but it'll be interesting to follow the briefing in that case when it's done. So that's the end of the young Dolph case. I hope you've enjoyed it. I hope you found some of the coverage here to be, reliable, interesting, hopeful. If you have any comments, drop them in the comments down below, or you can email me at the address above. Thank you for watching. If you have the opportunity today, do something nice for someone. Otherwise, come on down, catch me at the beach tomorrow. Hey, as I said at the beginning, none of what I said is legal advice, but let me tell you what, the stuff that's going to be right up here, these are the things that YouTube thinks you might be interested in going forward. Have a terrific day.